National Land Commission. I'm accompanied by two of my colleagues, Commissioner Hubi Hussein and Mheshimiwa Tia Galgalo. From the Commission, we are here to listen to historical and injustice claims. This is under our mandate in the Constitution to listen to historical and injustices that happened between 1895 to present. We had put an advert in the newspapers and we had invited communities to lodge claims with the Commission. That was until September 2022, by which time we had received over 3,000 claims from all over the country. In Garissa, we received 3 of them. Those 3 are the ones we've come to listen to today. We hope to be here until tomorrow. So today we listen to the 3 claims. Most of them touch on land that is either occupied or being used by either the military or the GK prison and other government facilities. And the claims are either during the colonial times or post-independence. Successive governments either forcefully evicted the communities for developmental purposes. In some cases here, as we listened, were security-related issues without compensation. And those communities therefore are here to claim. This is based on the new constitution, which allows communities to raise this injustice. So as a commission, we will listen to them, and where there is sufficient evidence, then the law allows us to give certain remedies, which include either returning the land to them or offering compensation in a number of ways. So that's why we are here for these 3 days. After these views, of course, as a commission, we'll retire, we'll write our decision, and we will give the decision for implementation by the various government agencies. As you know, as a commission, ours is to listen, to analyze the cases, and then give a decision. But other arms of government are the ones with the responsibility of implementation. What I would like to bring out is the time for submission of claims ended in 2022. However, there is a bill that was put in Parliament requesting for extension of time. Like I mentioned, Garissa only gave us three claims. We know there are many more, and maybe it's because of what you're saying that either for varied reasons, those who actually had cases were never able to come forward. Our appeal, therefore, is the bill went through Parliament, was passed. It is before the President. Hopefully, the President can be able to assent to it so that we can allow the communities that were left out to be able to bring their claims. The other one also would be to ask to build confidence within the country and for this process. For the decisions that are being made, then government should be able to implement. Whatever government agency that is charged with the responsibility of implementation, then let be done. For instance, you've had, like one of the prayers today we've had is about resettlement, which means these communities are saying that since we were removed from our pieces of land, we've not been able to go back, or we do not have a place where we can call our home. Should the Commission find those claims credible and justifiable, and for instance say we order that the land be returned to them or they be resettled, then the responsibility falls with the national government to identify the respective land and make sure those communities are settled. If we order that they need to be given compensation, therefore then whatever has been quantified is for national government to budget for those monies and make sure those communities then are compensated. So I think that would build confidence in the process and ensure that actually communities are able to come forward. We address these historical issues that communities keep on carrying, a trauma within our communities. They've carried for so long, and all this they're attributing to either government or government institutions. So I think it's important that for us to be able to address. I think we need to we need to clarify that there are different roles played by different institutions. Under the old dispensation, local authorities were able to process land up to a certain level. So they'll be able to either, like in Town Plus, they would put, using the Commission of Lands, they'll be able to put notices and allocate land. But they're not issuing allotment letters. They may call them allotment letters, but they're not really allotment letters. The allotment letter was coming from the Commission of Lands. Even the current situation, the process would start with the counties, planning, surveying. Then they would request the Commission to allocate the land. It is the Commission that will issue a letter of allotment, should they find that process to be credible. Once the letter of allotment is issued, a lease is prepared, then it is registered with the national government. That should be the process. So there should be no confusion between who is supposed to do what. There is only one valid letter of allotment. Currently, a letter of allotment issued by the National Land Commission. In the old dispensation would still be a letter of allotment issued by the Commissioner of Lands. So any document that is issued by the county should be seen as a primary document that can be used for further processing of the rights that are supposed to be given to that document holder. So I think let us not have confusion about who's supposed to issue a letter of allotment.
To add up to that, the process is that letter of allotment is actually given by the National Land Commission, but the role of the county government is to give no objection letter by the CEC. And then you are supposed to have approved BDP from the county also. And then you are supposed to have approved survey plan. With those three documents, you come to the National Land Commission, register with us, and we look at your document. We see whether there's double registration, whether there's another existing person claiming the same. If no one is claiming, we give you the letter of allotment. And then you take the same letter of allotment to the Ministry of Land to process your title. A double registration have been registered. We have seen that, and those are corruption issues. And some of those titles come from River Road. They are not genuine. And even the ones coming from Ministry of Lands are not genuine. It's through corruption that they are being given. If you follow them up properly, if you do the search, you will not find that name that is holding that title, because it's corruption issue. Somebody sits somewhere and gives you a title deed, which is not right. And these days, there is no title deed given. What is given is lease letter. Yes, unless you are given a freehold. Our role as a commission is to listen to the complainant and to call the respondents, to hear from both sides, both the claimant and the respondent. And then if we find the claimant's claims are genuine, we give what's called determination. That determination will be implemented by the rightful authorities. Maybe if it is the Interior, if it is the Attorney General, we will give to the concerned authority to implement it. Ours is just to give determination, and some of our determination have been respected, like the Makinoni Road. What was the Makinon? Yeah, already the court has accepted, and that is solved. We are dealing right now with another one for Masai and Migori, which land belongs to who. And our determination is always respected. So we expect this one of Garissa to be respected, and we expect when the president assent to the new amendment, Garissa people will file their complaints, and we will listen.